Good morning. Today we are going to see Arbitration Act, a case law under Arbitration Act, and under the Micro and Small Scale Enterprises Act. Interesting question came before the High Court. The facts of the case is this. Naturally, there was a contract agreement between two companies. One is a small scale industry, another is a big public sector enterprise. So, the naturally, for small scale industries, there are certain conditions which have to be complied with. Once the invoice is raised, the condition was within 30 days, the amount has to be paid. And some earnest money was deposited by that small scale industry for taking the contract, etc. The, After the contract was over, the period was over, some disputes were there. Majorly, the dispute was with regard to non-refund of the earnest money deposit by the public sector enterprise to this small scale industry. The small scale industry first issued a notice, no reply. Naturally, public sector enterprises generally, I am not very sure about this, but it seems they have not replied properly. They have not even replied. So, under the uh, Micro and Small Scale Enterprises Act, they moved the Facilitation Council. Facilitation Council, the person was appointed. Uh, he issued a notice to the public sector enterprise. Public sector enterprise did not come for the hearing. Immediately, he passed an award. The Facilitation Council passed an award. You have to refund the earnest money deposit and with a huge interest amount. Then, after the order is passed, the public sector filed a writ petition before the High Court, saying that as per section 18.2 of the micro and small, micro, medium and small scale, whatever is the act, micro and small scale enterprises act, that 18.2 says that the facilitation council cannot straight away pass an award. First, they have to mediate. Only after the mediation, then uh, if the mediation fails, then they have to refer it to arbitration. Either they can conduct the arbitration by themselves or refer it to the council for an arbitrator to be appointed. And then only the arbitrator can pass an award. They have not followed the procedure prescribed under the law. Since they have violated the law, the order is an illegal order and hence it has to be quashed. This is the writ petition. It went before the single judge. Single judge, after appreciating section 18.2 of the act, he said, this order is a non-est order. That is, it is not valid in law. Because the section 18.2 clearly says that the Facilitation Council must first conduct the mediation and then only an arbitration can take place between the parties and an award can be passed. Since they have not followed the law, the order itself is bad. And one of the contentions by the advocate of the small scale enterprise is that there is an alternative remedy of filing an appeal. Uh, so the writ petition should not be entertained by the High Court. The High Court said, no, there is a condition of payment of 75% pre-deposit in case appeal has to be filed. This is a very, very important clause in Medium and Small Scale Enterprises Act, that you have to pay 75% pre-deposit in case you have to file an appeal. So the High Court said, no, it is a onerous condition. When the order itself is bad, so they need not be relegated to the remedy of alternative remedy of filing an appeal. And hence he said this order is bad in law. The High Court quashed the award passed by the Facilitation Council. Then the small scale enterprises filed an appeal to the division bench of the High Court. Division bench of the High Court also said that since 18.2 specifically says mediation has to be first taken place and then only the arbitration can take place, since the procedure prescribed under the law has not been followed, they quashed the award and they agreed with the single bench and then quashed the award, confirmed the quashing of the award. This is the interesting case. There are 2-3 observations. One is mediation is introduced, is there in the Medium and Small Scale Enterprises Act, and Supreme Court also said, Supreme Court in commercial courts, in commercial disputes, also there is a mediation. If the dispute is more than 3 lakhs, first you have to go for mediation. Unless in urgent cases, there is one exception is there. Other than that, it is compulsory that you have to go for mediation. The mediation may be successful, may not be successful. But you have to go for mediation and then only you can file the suit. Otherwise, you cannot file the suit. Supreme Court also says that in Commercial Act. Secondly, the interesting point is the consumer cases. If you go to Consumer Protection Act, many cases are filed in consumer courts. N number of cases, starting from 500 rupees to crores of rupees. A number of cases are filed and consumer courts are finding it difficult to dispose of the cases. It's actually the time taken by there are no members or judges are there. Even if they are there, in my view, the consumer courts are not very effective, except in very few places. So what happens is, why there is no mediation? In the Act, in the Consumer Protection Act, they should also introduce a mediation. At least both the parties can sit together, and then in my view, in consumer cases, mostly, if the mediation is effective, many of the cases may get disposed of. The litigation may be reduced to a major extent in consumer courts. This is my point of view. Anyway, this is the case. Thank you very much. Have a great day.